Welcome to the Alliance Educational Series. In this collection, we're learning about strategies for signing a fair contract. As we introduced in another video module, a contract creates a serious legal relationship between the parties who sign. We also mentioned breach fees, the dollar amount you'll owe if you break a contract early. You should avoid breaching a contract. But what if it's not possible to avoid a breach? In this video, we'll talk specifically about what to expect in situations where a contract is breached by either you or your recruiter or employer. First, we talk about your responsibilities after signing. We talk about two situations where a contract may be broken, and your rights and responsibilities in each one. Next, we discuss how most state courts decide whether a breach fee will be enforced. We end the module by sharing 3 things you can do if you feel you have no choice but to break your contract. The goal of the Alliance Educational Series is to give migrant professionals the information to make choices about what's best for you. However, the Alliance does not give legal advice, so if you are thinking about breaking a contract, consult a lawyer about your rights, responsibilities, and state laws. You can also visit the Alliance website for a list of helpful resources. In this educational series, we have talked a lot about what foreign educated professionals can do before signing a contract. Let's start by talking about the kinds of things that can happen after it is signed. After agreeing to and signing a contract, recruiters and employers invest a lot of money to help with immigration and job preparation. Then, employers such as hospitals and healthcare organizations spend more money to get a migrant ready to work. Signing sends the message that they can safely invest in you, as opposed to another healthcare professional. What happens if a professional breaches his or her contract? Breaching is a big problem for employers and recruiters. If everyone breached, recruiters could stop working. Employers would lose the money they paid to the recruiter and spent on orientation. They would probably stop recruiting internationally or avoid people from a specific country or from specific recruitment agencies. So, breaching a contract is a serious choice that impacts not just you, but many other people. That is why you should only sign a contract when you are serious, committed, and satisfied with the terms. Never sign a contract just to get to the United States. But what if you cannot avoid a breach? Remember that at least 2 parties sign a contract and either side can breach. That gives us 2 types of contract breaches. The first type is the responsibility of the professional. In this first situation, a professional may choose to break a contract early. In this case, you are responsible for the consequences. Your contract should explain your responsibilities or obligations. As we discuss in the module What is a breach fee, paying a penalty is a common responsibility in this situation. Your contract should explain how much to pay and how the amount is calculated. The second type of breach fee occurs when a professional's recruiter or employer does not respect the terms of the contract. In this situation, you may find that the salary, hours worked, job location, or type of work promised were changed. Then, the employer or recruiter is responsible for the consequences. Your contract should explain your rights. For example, you may have the right to leave the job without penalties if they broke the contract in a material or significant way. If you find yourself in either situation, you should talk to a lawyer. Again, you can visit the Alliance website to find a list of resources that will help you know who to call. What happens if one party breaches the contract? Breaching often means going to court to discuss breach fees. In the U.S., each state's court is responsible for laws about contracts. We'll describe what most state courts do, but with 50 different states, there can be a lot of variation. Most state courts consider 4 things when making a decision. First, they want to know who breached the contract. If both sides breached, the court will want to know who breached first. the first party to breach is usually held responsible. Second, if the employer or recruiter is responsible, courts will want to know, was this a major or minor breach? A major breach, also called a material breach, is more serious. If a professional is paid much less than stated in the contract, courts might call this a major breach. Third, state courts want to know, is the breach fee reasonable? Determining whether a fee is reasonable is not always easy, but it either closely matches the costs of immigration and recruitment, or is some portion of the profit a recruiter or employer expected to make. Unfortunately, there are no clear rules in the U.S. about what is reasonable. Finally, state courts try to find out, was the breach fee part of a conscionable contract? Conscionable is a word lawyers and judges use for fair. Fair contracts are similar to others in the same field and signed willingly, without pressure. When thinking about whether or not a contract is fair, state courts might ask questions like, were you provided enough information about the details in your contract? Were you pressured or hurried to sign the contract without being able to carefully read it? Was the contract long, with many pages of confusing or unclear clauses? Was the section on breach fees clear? A real example will help us understand how state courts think about contract breaches. Sentosa Recruitment Agency signed contracts with a group of nurses in the Philippines. They indicated that the nurses would be hired as direct employees of healthcare organizations and would work at least 35 hours per week. After arriving, the nurses discovered they were employed by a staffing agency and that they were being paid for fewer hours. They had also been promised 2 months of housing, but the housing was a single-family home for more than 12 people, had just one bathroom, did not have enough heating for cold weather, and did not include a telephone. Breach fees of $25,000 for each nurse made it hard to leave their 3-year contracts, so the nurses complained to Sentosa. When the situation did not improve, they consulted a lawyer. The lawyer told them that Sentosa had breached, and that they were therefore free to quit, which they did. Sentosa took the nurses to court, both to collect the breach fee and to press criminal charges against them for abandoning their patients. After almost 3 years of trial, a state judge rejected Sentosa's arguments and declared that the 13th Amendment to the United States Constitution protected the nurses. In particular, the judge decided that the $25,000 breach fees were unconscionable because the nurses did not have a chance to negotiate fairly in their home country. In the Sentosa case, the courts decided that Sentosa breached the contract first, and that it was a material breach. The case did not address whether or not the $25,000 breach fee was reasonable, but it did determine that in this case, the fees were unconscionable because the nurses were pressured to sign contracts. In the best situation, you'll carefully read your contract and negotiate for fair terms before signing. However, there are some situations when professionals may feel they have no choice but to breach. In these situations, there are 3 things you should do. First, know your rights as a worker in the U.S. Federal government websites can help you learn more about laws to protect you. You can also contact your embassy, U.S. professionals associations, unions in your state, and non-governmental groups for information and help. Second, be sure you understand the details of your contract, especially if it includes a breach fee. Review your copy of the contract to understand how the fee may be collected and how much you'll have to pay. This includes knowing if your fee drops based on how long you work and whether the other party will try to charge interest payments. Learn about how your fee is calculated in the video module called What is a Breach Fee? Third, keep copies of all important documents, conversations, and emails. This may include taking notes. All of these materials could help you if you need to go to court. Hopefully, a court case is the last choice for you and your recruiter or employer. Court cases are expensive for both sides. Even if you win, and the employer or recruiter must pay your legal fees, it is very time-consuming and emotionally exhausting. That is why it is so important to understand your rights and your contract before problems arise. In this module, you learned about how signing a contract affects many different people involved in international recruitment, and how important it is to avoid a breach if possible. We reviewed 2 types of breaches and some of the questions a state court will likely ask if a contract breach becomes a lawsuit. We finished by offering 3 strategies to consider for professionals who feel that they must breach a contract. Please remember that the Alliance does not offer legal advice. Breaking a contract means breaking a legal relationship. You should try to get legal advice before taking any action. Now, show what you know. Who is not affected when a contract is breached? A. International recruitment agencies. B. Employers, such as hospitals and healthcare organizations. C. Other migrant professionals interested in working in the United States. D. Your university or college. E. None of the above. A contract breach affects all of these parties. The correct answer is D. Your college or university is not part of signing a contract or the international recruitment process. It will not be affected if a contract is breached by either party. Breach fees are very important to understand. Try one more question to test your knowledge. Which of the following is true about contract breaches? A. Being pressured to sign a contract without a chance to negotiate is unconscionable. B. Breach fees of $25,000 are unreasonable. C. Employers who change contracts without a worker's consent will not have consequences. D. Asking a lawyer for advice before breaching a contract is illegal. E. Breaches are only considered material or serious if committed by an employer. The correct answer is A. You have the right to carefully review and negotiate changes to a contract before signing. The Alliance is here to help inform you and link you to resources. Join us on Facebook to get regular news. Subscribe on YouTube to have quick and easy access to other modules. You can also use the open reporting feature on our website to let us know about any problems you're having in the international recruitment process.